Good morning, everyone. We're going to go ahead and call the Senate Judiciary Committee to order. I want to thank everyone for being here on a bright early Monday morning. Hope everyone had a great weekend. We're going to start off with the bottom of the list on our public hearings. We're going to start with Senate Bill 362. And so, Chenna, if you'll give us an overview, please.
Chair Brzezinski, I'm going to direct you to Ms. Fisher.
Oh.
Good morning. Chair Brzezinski, members of the committee. Senate Bill 362 requires a defendant to file notice of intent to introduce evidence of mental defense at least 45 days before trial, authorizes the court for good cause to allow defendant to file notice within 45 days before trial.
All right. We have two individuals that are signed up to give testimony today, Jeff Auxier and then Aaron Knott.
Chair Brzezinski, members of the committee, my name is Jeff Auxier. I'm the Columbia County District Attorney, and I'm also here on behalf of the Oregon District Attorneys Association. I'm here to speak about the Senate Bill 362 in favor. Recently, in 2017, a Court of Appeals decision came out entitled State v. Robinson. That decision eliminated a presumption that existed in most trial courts, which was that the defense had to file sufficient notice in order for the prosecutors to have ample time to send a defendant to the state hospital for an evaluation, an independent evaluation to determine if someone was guilty except for insanity. After Robinson, that presumption was eliminated, and the court said the plain reading of the statute suggested no advance notice was needed. As a result, prosecutors and crime victims are at risk of finding out the morning of trial that a defense attorney intends to make an insanity defense. The prosecutors are not given any opportunity to get an independent evaluation from the state hospital to determine if they agree or disagree with the insanity defense. And one result of this is that the prosecutors have to decide the morning of trial whether to ask for a continuance and tell victims that they have to wait even longer for their trial, or go to trial without the benefit of an independent evaluation with one hand tied behind their back. Another disadvantage of this court ruling is that, quite frankly, prosecutors don't have an opportunity to get that independent evaluation, which in many cases would prompt the prosecutor to agree with the defense attorney and craft a sentencing outcome that took into account the mental illness of the defendant. And so for those reasons, we're asking for your support for Senate Bill 362.
All right, thank you. Aaron?
And thank you, Chair Brzezinski, members of the committee. For the record, my name's Aaron Knott. I'm the Legislative Director for the Attorney General in the Oregon Department of Justice. Likewise, here in support of Senate Bill 362. DA Auxier did a good job of providing overview background on what this is about. Basically, post-Robinson, if a defense attorney wishes to file notice that they intend to rely on the defense of insanity, if they're aware that they're going to do that at the time of arraignment, that is, the first appearance of the defendant, they're required to furnish that notice. However, after Robinson, they are then free of any obligation to furnish their intent to rely on that defense until the day of trial. Every once in a while, the Court of Appeals sends a particularly strong message to the legislative branch that they believe that they've discovered a statutory infirmity that only the legislature is well positioned to correct. And I believe Robinson is one of those cases. I'll quote briefly from that opinion. By authorizing a defendant to file the notice at any time before trial, the statute creates an incentive for defense counsel to wait until the eve of trial to file the notice in order to protect the defendant from the psychological examination to which the state is entitled upon filing of the notice. But this leaves the state with a difficult decision, whether to call off the trial for which witnesses have been subpoenaed and jurors summoned in order to conduct an examination, or to proceed to trial without the evidence to which it it is entitled, "None of this is conducive to the fair and efficient administration of justice. The situation would not be difficult for the legislature to remedy." We call upon you now to do so. That is what Senate Bill 362 is designed to accomplish, and I am open for any questions.
All right, questions for either individual? Senator Bentz.
Mr. Chair, how long does it generally take to obtain an independent review?
Do you want to go after that one?
Senator Bentz, Chair Brzezinski, thank you for the question. I would say on average, the state, you're looking at 30 days to 60 days for a state hospital evaluation to be returned.
All right, any follow-up? Jeff, pleasure meeting you. Aaron, thank you very much. Is there anyone else who wants to testify today on Senate Bill 362? Anyone coming forward? We're going to close the public hearing. Colleagues, what we're going to do is go into our work sessions on two bills so we can let staff get back to other work. So I'm going to open up a work session first on Senate Bill 783. And I think, Chenna, you're going to give us a quick overview on that? Oh, it's right. Oh, Jillian. Yes, I'm sorry. It's Monday morning. I'll get with the program.
Out of your purview. Chair Brzezinski, members of committee, Bill 783 is relating to elder abuse proceeding and modifies the requirement to notify the Attorney General of elder abuse proceedings, making failure to notify not jurisdictional defect, conditions entry of judgment for plaintiff on proof of notice. And we were waiting on the fiscal impact to be returned on this. There are -1 amendments which were testified to last week, and they just modify that the judgment also cannot be entered in favor of the or against anybody unless the notice has been filed. It did not change the intent of the bill or the effect of the bill. This has a minimal my computer just shut down. Minimal fiscal impact.
A little bit, just not much.
No.
All right, so, and then my understanding, we do need the -1s?
They are done. We
They're
have
done.
them.
So
Oh, we do need them, yes, we need them adopted, and I'm sorry.
Okay.
Okay, Chair Brzezinski, I move the -1 amendments to Senate Bill 783.
Senator Thatcher moves the -1 amendments into Senate Bill 783. Any discussion? Any objections? So ordered. Senator Thatcher?
Okay, Chair Brzezinski, I move Senate Bill 783 as amended to the floor with a due pass recommendation.
Senator Thatcher now moves Senate Bill 783 as amended by the -1s to the floor with a due pass recommendation. Any discussion? Any objections? So ordered. We'll ask Senator Taylor to be the carrier on that bill since she's a co-chief sponsor. If that fails, then our backup, Senator Gelser, will take it, and we'll go and close the work session on Senate Bill 783. We're going to open up a work session on Senate Bill 777. Colleagues, this is only to refer the bill out of our committee to another committee that is, I guess, better poised to deal with this. So, Senator Thatcher?
Chair Brzezinski, I move Senate Bill 777 without recommendation as to passage and with recommendation that the bill be referred to the Senate Committee on Education.
Senator Thatcher moves that Senate Bill 777 without recommendation as passage with the recommendation that the bill referred to the Senate Committee on Education. Is there any discussion? Any objection? So ordered, and it's on its way to education. We'll close the work session on Senate Bill 777. And now we're going to open up our next public hearing, which will be on Senate Bill 763. And Chen, I think we're back to you now on
All
this
right,
one.
thank you, Chair Brzezinski, members of the committee. In Oregon, a person may be civilly committed when there is, by clear and convincing evidence, shown that a person has a mental illness and voluntary treatment or conditional release are not in the person's best interest. A person with a mental illness is defined as a person who, because of a mental disorder, is one or more of the following: a danger to self or others, or unable to provide for their basic needs. The dangers to self or others standard is not defined within statute, so it's been left to case law to come up with what that means. The type of danger necessary to justify an involuntary civil commitment is a narrow range of serious and highly probable threats of harm. It cannot be based on an isolated threat of suicide, speculation, or behaviors that, while they may seem concerning, are not actually dangerous or serious harm. The harm must be of a serious nature and stem from the mental disorder. Senate Bill 763 is the product of an interim work group who had a lot of discussion on this particular issue. It provides definitions to those terms for the civil commitment statutes, defines dangerous to self or others as meaning likely to inflict serious physical harm upon self or another person within the next 30 days. Additionally, it allows the court to consider threats or attempts at suicide or harm to others and any past behaviors that resulted in physical harm to self or another person. In considering the prior behaviors, the court must consider the relevance of the person's past behavior, how recently the past behavior occurred, and the frequency and severity of the past behavior.
All right, we have a number of individuals who are going to be giving testimony on this bill as well as the second bill that parallels. So I'm going to first call up Judge Wilkie, Dr. Berry, and Commissioner Sean Myron, maybe?
Last one, David. Sharon.
Sharon, okay, well,
Myron was good.
We're really squeezing in there. My eyes only go so far, sorry. I'll put the O back in there. All right, Judge Wilkie, are you going to be the lead off here?
I'd like to, Senator Prozansky, Vice Chair Thatcher, and Senators, Senate Bill 762 and 763 have been submitted at the request of the work group to decriminalize mental illness, of which I was co-chair with Senator Prozansky.
All right, and Judge, I need you to put your full name on the record.
My name is Pat Wilkie. I'm a circuit court judge from Josephine County, which is Grants Pass.
And I know that you're doing the intro, but I just want to make certain everyone understands right now we're taking testimony on the 763.
Okay. First, I'd like to extend thanks to Senator Prozansky for allowing and participating in this work group. I'd like to extend thanks to this entire committee for sponsoring the work group, and especially Chana Newell. In 42 years as either a practicing lawyer or as a judge, I've seen many lawyers. I can tell you that Chana is a very good lawyer. She also took on the burden of organizing our meetings and doing a lot of very high-quality legal research. My interest in serious mental illness started when our son, in his freshman year at the University of Oregon, developed a serious mental illness. After about 2 years of struggle, we went through the civil commitment procedure for our son, and by the smallest of margins, he was civilly committed. I still remember the deputy district attorney talking to me before the commitment hearing and say, I don't think we have enough evidence to commit Billy, which was a real shock to me. Because of the civil commitment, our son has engaged in proper services and is leading a successful and happy life for the past 16 years. In February 2009, I started the Josephine County Mental Health Court and continue to preside over it. I worked for the passage in 2013 of our statute on assisted outpatient treatment, which is ORS 426.133. And I've organized the Oregon Mental Health Judges Association, and a list of those judges has been enclosed to you. The work group's first meeting was in September 2017, and the last meeting was in January of this year. We had a total of 9 meetings, often in this room. Our membership was open to a wide and diverse group of participants. A copy of the members' list has been submitted. My fellow witnesses here today are members of the work group. At one time or another, we had up to 50 members, although not all at the same time. We had representatives of state agencies, the Oregon Health Authority, the Department of Justice, the Judicial Department, and the Oregon State Hospital. We had many mental health and medical professionals, including at least 3 psychiatrists. We had many attorneys interested in this area, including Aaron Knott, who you've just heard from, Inge Wells from the Appellate Division. Our star member was retired Supreme Court Justice David Brewer, who was nice enough to come out of retirement and actively participate. He was unable to be here today, but his letter has been submitted for your consideration. And finally, we had many interest groups. We had representatives of NAMI, Disability Rights of Oregon, American Civil Liberties Union, Oregon Criminal Defense Lawyers Association, law enforcement, APPEAR, Oregon Psychiatric Physicians Association, and the Treatment Advocacy Center. Our focus was on 3 areas of reform: civil commitment, assisted outpatient treatment, and pre-hearing detention. Civil commitment is mainly what has been dealt with in Senate Bill 763. As you may know, almost every other state in the union defines the criteria for civil commitment within the statute. Oregon does not. We merely say that you can be civilly committed if you have a mental illness and are a danger to yourself or others. So what does that mean? What does that really define? Dangerousness is truly a very vague and subjective term. What is dangerous to me may be safe to you or slightly reckless to someone else. The current vague criteria is used not just by judges in civil commitment hearings, but by police officers and hospital personnel. So on the street, a police officer has to decide whether he can execute a police officer's hold on somebody that is threatening to do a homicide, maybe a mass homicide, based on this extremely vague criteria. And really, to know the answer to that, he would have to be updated in all the most recent appellate decisions. We began our process by reviewing the definitions for civil commitment from all 50 states. We took them home, studied them, discussed them over many meetings. We finally decided to start with the Missouri definition. This is after people came and said, I like the Colorado definition, I like the Michigan definitions, and we finally kind of coalesced around Missouri. That was our starting point, and from that starting point, after many more discussions, we added and subtracted from that and ended up with Senate Bill 763. In this legislation, we have defined the term of dangerousness, the time frame, and the evidence that can be considered by the trial court in determining dangerousness. Another focus of our work group was assisted outpatient treatment. The work group decided to leave the statutory language as it currently is. Rather, we focused on how we might make this a useful remedy to intercept seriously mentally ill individuals before they are at the level where they need civil commitment. So it was an attempt to lessen the civil commitment population by doing something. The remedy was either to do nothing at all or proceed to civil commitment. So AOT, or assisted outpatient treatment, is kind of middle ground. Doesn't require inpatient commitment, does require that the person under a court order engage in treatment. To that end, 6 of us traveled to Ohio in October of 2018 to observe 2 established AOT dockets, one in suburban Cincinnati and one in Akron. We anticipate that there will be one county in Oregon, hopefully Multnomah County, which will set up a high-functioning AOT docket. And once that is done, we expect other counties to emulate that. And then finally, pre-hearing detention, which is Senate Bill 762. As you probably know, the maximum limit for any involuntary hold in Oregon is up to 5 days, and that's the same limit that has to be honored before there can be a commitment hearing. So if you don't have the commitment hearing within 5 days, then you either don't have the hearing at all or the person is released. The problem with that is that people with a serious mental illness who are actively psychotic will not begin to recover in 5 days, even if they immediately start taking psychotropic medicines. As a result, the individual rarely receives any treatment during any hospital stay. They are quickly released back into the community in essentially the same condition to repeat the cycle over and over and over again. Medicine can work if it's given a little more time. Antipsychotic medicine can work. And in my 10 years as a judge of the mental health court in Josephine County, I've seen this over and over again, that people will come in, their first appearance in court, they will be psychotic and they will be rambling, and they agree to start taking their medicine, and within a couple weeks, they are back to their old self. So we can get to that if there's a 15-day extension, and there are procedural safeguards in Senate Bill 762 to make sure that that is not without due process to the mentally ill person. So with that brief overview, I would invite any questions you may have, and I know we have many well-qualified witnesses that I also want to defer to. Thank you.
All right, thank you. And who would like to go next?
Thank you. Chair Przansky, Vice Chair Thatcher, and members of the committee. My name is Sharon Myron, and I'm a Multnomah County Commissioner and also an emergency physician. I'm grateful to this committee for considering Senate Bill 763. As an ER doctor for over a decade, I've seen thousands of people who have come to the emergency department in a mental health crisis. Some people are brought to the hospital by a loved one, often at a tenuous and fragile moment where there's a brief window of opportunity and a willingness to seek support. But too often, we see the same people over and over because their circumstances leave them cycling through the streets, the jails, and the emergency department. So many of these cases I have family members coming to me and supporters of the people who are coming in, experiencing the crisis, talking to me about their sense of frustration, helplessness, and despair in seeing the person they love whose struggles propel them far into the margins, but not quite far enough to get help. This dynamic is one I'm deeply familiar with as an emergency room doctor. I worked a shift yesterday, and actually it comes up literally every shift. But it was brought into renewed focus for me at the policy level as a county commissioner. In early 2017, Multnomah County experienced a record spell of freezing temperatures, temperatures in the teens, snow, and on January 7th, 2017, in the middle of the day in a downtown parking garage, a woman named Karen Batts, 52 years old, froze to death. Nearly 2 months after her death, I sat in my office with her family, her brother and her mother, and I learned more about her family, and about all of their struggles throughout the years with mental health challenges. I learned about all the systems that Karen had come into contact with, a lot of the things that people really did right within those systems, and all the supports that she did have available. But what strikes me is that even with all of these supports and interventions and touch points available, Karen still slipped through a major and devastating crack in our system. Oregon currently has one of the strictest laws in the country in terms of when someone can be civilly committed, including when they can be required to take medications and what authority providers have to direct their care. This high bar clearly exists for a reason, and I do not take lightly the fundamental importance of civil rights and people's right to self-determination. But I think that we can and must do better by one another. I believe that we can better balance an individual's rights to self-determination with their right to receive assertive, compassionate care when they are not able to provide it for themselves. Senate Bill 763 provides an opportunity to shift this balance thoughtfully and intentionally toward a legal framework that is better able to meet the needs of people in crisis. I appreciate the hard work, challenging discussions, and honest debate that's been part of this process to produce this legislation. I also appreciate the steadfast vigilance of advocates and people with lived experience in the discussion who remind us that we should not and cannot loosen the statutory threshold for involuntary treatment without simultaneously improving the availability and accessibility of less restrictive mental health services in communities across our state. Whether people receive treatment voluntarily or involuntarily, we know that they do better when they have the benefit of social and community supports. I can't say whether the changes in Senate Bill 763 would have saved or made a difference for Karen Batts, but I can say this measured change in how we assess, understand, and respond to people experiencing mental health crisis will make a meaningful difference for others in the future. Thank you so much for your consideration of this important legislation, and I urge you to support Senate Bill 763.
Sure, thank you. And Doctor?
For the record, I am Dr. Will Berry, Chair Brzezinski, Vice Chair Thatcher, and members of the Senate Judiciary Committee. I'm a psychiatrist, and I'm the medical director of Deschutes County Behavioral Health. I teach the annual seminar in civil commitment for the Forensic Fellowship at Oregon Health and Science University, but most of the work I do is as a psychiatrist in the community. And in that role, I lead some specialty teams that try to address some of the high-risk populations in our state. One of those teams is for the Early Assessment and Alliance, or ESA group. These are young people who are having oftentimes their first experiences of a psychotic illness. And these teams often try to intervene with young people and their families as they first may be beginning to develop symptoms of an illness such as schizophrenia, so that we can work with them and work with their families and the communities to hopefully try and prevent the illness from progressing before it gets treatment. Another team I work with is I'm the physician for people under jurisdiction of the Psychiatric Security Review Board. This is the board in Oregon that manages people who have been oftentimes committed or been involved in a serious crime and been given a verdict of guilty except for insanity. In working with these two teams, I have daily and intimate interaction with people both towards the beginning of their course of mental illness, often before maybe something tragic has happened when they need treatment, and also people and their families after something has happened, the consequences of which they live with on a daily basis. I'm here today on behalf of the Oregon Psychiatric Physicians Association in support of Senate Bill 763, which clarifies the definition of danger to self or others. The role of civil commitment in society demands careful balance. Civil commitment is a life-saving clinical tool, but it is a tool of last resort. In most cases, civil commitment never occurs and never needs to occur. This is how it should be. Nevertheless, for some members of our communities who suffer from the most serious forms of mental illness, civil commitment can also be a necessity and a path to healing. For the person who is suffering a severe mental health crisis and where all other options have failed, such treatment may be the only alternative to severe outcomes such as homelessness, incarceration, or death. Our system must strive to find balance within this complicated reality. Our current civil commitment law fails to strike such a balance and therefore fails the people who need it most. The standard for commitment in Oregon requires a person due to a mental disorder to be dangerous to self or others, or to be unable to provide for basic personal needs. However, without such concepts being defined in the law, they've been interpreted by courts as to only apply when such dangers are imminent. This standard of imminence, which manages to both be narrow and vague, is ineffective, failing to allow for reasonable clinical prediction or to provide clear guidance to the court as to what evidence should be considered. The all too common result is that someone in crisis is turned away from treatment when they need it most. Doctors, law enforcement, families, and patients know this message all too well. We understand your concern, but it's not imminent enough for us to do anything. The results are often tragic if predictable. Left without a resolution in a clinical setting, these crises follow a different path towards homelessness, arrest, incarceration, or worse. In the meantime, conditions that often can be managed if they are treated early are left to deteriorate. This bill would allow persons in crisis due to a mental disorder to be treated without an arrest and incurring the burden of a criminal record. It would allow more people to receive treatment in their community instead of ending up in jail and then being sent to the state hospital as an aid and assist patient. And it would allow clinicians to try to intervene in severe cases prior to serious harm coming to that person or someone else. Over the last several years in this state, I've heard much talk about decriminalizing mental illness, but let us be clear. If a person can be dangerous enough to go to jail, but not dangerous enough for treatment, efforts to shift treatment away from jails and prisons will fail. One case I know of involves a young woman in the early stages of schizophrenia who developed delusions that her mother was involved in a plot to murder her and sell her organs. Her mental health team worked with her for months. She received peer support services, help with supportive housing, medical care, and attended groups with her peers in a recovery-based model. Unfortunately, she could not be persuaded to take medication, and her condition worsened. This woman, who had no prior history of violence, began having multiple incidents where she attacked her mother, which in the midst of her psychosis, she perceived as self-defense. Police and crisis teams were called each time. They shared the team's concern, but the decision was that familiar refrain: she was not an imminent risk. Their hands were tied. We knew commitment was needed, but there was nothing the team could do, and her mother expressed shock that these attacks were not enough for her daughter to get treatment. After a tense period of several weeks, a more serious assault occurred, sending her mother to the hospital. Finally, she did get civilly committed, but only after an arrest and serious charges to face upon her hospital release. There are more tragic cases that I could describe, but I chose to share this case because it is both typical and instructive. The fundamental purpose of civil commitment is to try to provide treatment after all other clinical options have failed, but before something terrible happens. As it stands now, we must wait to treat some people until severe harm is imminent, really by waiting for disaster to strike and then trying to pick up the pieces. Such a system does not protect the freedom, health, and lives of those people and the people around them. Instead, it simply pushes the problem back to our emergency rooms, our streets, and our jails. The woman whose story I just told is doing well now. She did not want to be hospitalized or receive treatment initially, but she is back living in her community, and she takes her medications willingly. Her mother feels like her daughter is back. With treatment, her delusions have resolved, and she recently got a job. She's in stable housing, and she's working with her public defender to address the charges. She and her mother are working to heal their relationship, and both will live with the traumatic memories of the violence between them for the rest of their lives. I believe this bill is a step towards balance. It will not make civil commitment common. Our system of checks and balances with doctors, investigators, and the court all playing a part remains intact. And the threshold for civil commitment remains high, ensuring that community-based, recovery-oriented, voluntary treatment remains the cornerstone of care in our state. But for those in the most severe crises, it allows us to push for quality treatment and shift the burden away from criminalization. Thank you.
All right, thank you. Questions for anyone on the panel?
I just have a,
Senator Thatcher.
don't know if it's a quick question or not, but I keep hearing that there's a lack of resources in the community, like there's just not enough. Maybe that's just a question for another day, but we need to figure out how to get more resources so that when we have people to refer, there are places for them to go. And so I'm hoping there might be a work group on that. So we can
We'll all be playing the lottery.
so maybe it's not a question.
Make some
just
money.
a comment.
Yeah, all right, thank you.
Oh, well, yeah, but if you have, do you have a solution?
I don't have a solution. I think it's true, but I would also want to make a qualifier. As a community psychiatrist, we will always take more resources, both in a treatment setting and in a social services setting. For example, more supported housing, more step-down facilities for people to stay. I think all of those things are very important. I also think it's important to emphasize, though, that there are some of the patients, and especially some of the persons who may be most appropriate for an intervention like civil commitment. In some of those cases, any amount of community supports may not work. And some of our most intensive teams, for example, the ACT model, which stands for Assertive and Community Treatment, we have a team like that, and that team has peer service providers, it has case management, therapists, a nurse, a doctor. It also has supportive housing and supportive employment. So it's a very intensive team that goes out into the communities, into the shelters, into the streets to work with people. It also works with jail diversion and forensic diversion teams in our area. And sometimes in those cases, if somebody is suffering from acute psychosis and they're not capable of realizing that they're suffering from an illness and need help, any amount of help that we offer, and no matter how holistically we offer it, may not be effective because the person cannot appreciate that help is what they need. So.
All right, thank you all very much. I'd like to go ahead and bring up the next panel, and that's going to include Paige Clarkson, Sheriff Myers, and I hope it's Casper.
Yes. Great.
Chair Przansky, members of the committee, for the record, my name is Jason Myers. I'm the Marion County Sheriff, and I'm here today representing the Oregon State Sheriff's Association and the Oregon Association Chiefs of Police. I'd like to begin first by thanking you, Chair Przansky, for putting this work group together. It's a very important issue, and Judge Wolke for his leadership and the kind of guiding this work group to this recommended policy. The question that I most often get asked in the community is, what are the biggest issues in public safety? And I will tell you, without skipping a beat, I tell people that it is the amount of people with behavioral health issues and needs in the community, or addiction, or homelessness that really drive the resources of public safety. I'm going to take you on a walk back in time. In 1990, when I started as a police officer, as a deputy sheriff, when we encountered somebody that was a danger to herself or others, it was fairly easy to get them treatment, to get them help in the time of need. And over time, we've watched that bar raise and people not be able to access services. And unfortunately, Dr. Berry articulated it very well, the criminal justice system has kind of become the de facto mental health system. And it's not geared to provide those services. Now, we've done a great job in Marion County with the assistance of the state through the incentives that have come through OHA. We've developed a lot of programs where we deflect people from the criminal justice system and they can access community-based treatment. But there's still work to be done. Just a recent survey of our jail, about 40% of the individuals in custody have behavioral health issues. And as I said, the criminal justice system, jail in particular, does not help these people. They get worse, not better. So I'm very supportive of this, of Senate Bill 763. I think it helps. It certainly will help the areas in the state that don't have the resources like Marion County, where access to services are difficult. And so I'm in full support, and I'd be happy to answer any questions that you might have.
All right, thank you. Who would like to go next?
I'll go next. Thank you. Chair Przansky, Vice Chair, Senator Thatcher, members of the committee. For the record, my name is Paige Clarkson, and I have the privilege of serving as the district attorney here in Marion County. And I, too, am here this morning in support of Senate Bill 763. The sheriff and I find ourselves together in places a lot, echoing the sentiments that he just spoke of, specifically that one of the biggest issues facing us in public safety is these behavioral health issues, often that are co-occurring with addiction issues and similar struggles that these individuals have. And another phrase that the sheriff and I use quite regularly is how in law enforcement it is really our goal to seek upstream intervention, meaning intervention of civil systems and community programs and services that can be available to these individuals before we have to engage a very costly and complicated criminal justice system. Many of these folks that we are talking about that could be eligible for a civil commitment process simply aren't being civilly committed because of that high bar, that high burden that you've already heard about this morning that has come to us via case law because of the vagueness of that statute and the definition of dangerous to self or others. And because of that high bar, we see individuals who could be otherwise civilly committed that will come back in the process over and over and over in a civil commitment setting. In Marion County, this is not the case in every county across the state, but in Marion County, my deputy district attorneys handle civil commitment proceedings. And it is a source of continued frustration for them, and that frustration is a word you've heard already this morning. But that is a source of frustration for them because they see those same folks over and over and over, who everybody in the room can see needs help, but everybody in the room also gets to the conclusion that the statutory standard is not going to allow us to get there. So these same folks will cycle through the civil commitment process a couple of times without being committed, without receiving the help that they need, and then eventually the criminal justice system will be engaged because somebody will be at significant risk, or worse, somebody will get hurt. And therefore, with the criminal justice system is left with no choice but to file criminal charges in order to engage those services we tried so hard to engage those first few times in the civil commitment process. This is not good for public safety. It's not appropriate for our communities to be at risk, both the allegedly mentally ill person as well as our communities at large to be at risk because we haven't engaged those civil systems. And it's frankly not compassionate for these allegedly mentally ill people. It is frankly tragic to watch them come back through this system and not get the help that they need. And it's very frustrating for us in the law enforcement process to have to tell their families, this isn't enough. You have to wait for them to really hurt somebody. You have to really wait for them to really hurt themselves. That's not a compassionate way to manage this behavioral health population. And just as the sheriff said, I would echo that. We don't want to engage the criminal justice system to do this. To intercept them at that civil level is much better for public safety and much better for our community and these folks that need these services. So with that, I just wanted to impart that on behalf of my office, the Marion County District Attorney's Office, as well as the Oregon District Attorneys Association, which I also represent here this morning, we are very much in support of this clarifying of these definitions so that we can hopefully engage these services and get these folks help. And that is the point of Senate Bill 763. So thank you for bringing this here this morning.
Thank you.
Thank you. Good morning, Senator Przansky, Vice President. Well, there you go. I guess we're going. Demotion. I'm Ann Casper, and I feel like I need to tell you my background in these systems because as a peer, we're generally not regarded very well in systems. Oh, first of all, I want to say, Senator Przansky and Judge Wolke, thank you so much for addressing this problem. I really appreciate all the work you put into it. I just don't agree with it, with the solutions you came up with. And I think one thing is on the committee, there weren't enough people who've been through the systems who understand it. So for me, I have been on the local public safety committee, mental health, for 15 years at Multnomah County. I was at NAMI for 6 years as a volunteer, Disability Rights Oregon for 3 years, ESA, the thing that was mentioned about the teenagers for 3 years. I've worked with psychiatrists on innovative solutions in Italy, Japan. I helped build the Unity Center for Behavioral Health, and I left that 6 months before because I saw that it's not going to be very good. CATSI, the Crisis Assessment Treatment Center. So I've been in these systems helping to make better systems, and I just don't see that Senate Bill 763 is a good solution. Another thing, too, is that immigrants and refugees, so I don't see anybody here speaking for them. We have to be so careful with medications because we don't know the allergies. I was in Providence Hospital. There was a Somali man who almost died, literally died within 3 minutes of taking medication. And Senator Gelser was part of a long email process of another Somali woman. I've also had a Kurdish woman actually die as a teenager because of medications. So we have to be so careful about forced medications and make sure it works for everybody. Commissioner Myron mentioned Karen Batts, and it's so interesting because I worked with Judge Edward Jones. I don't know if you know him, out of Multnomah County, and the day that she died, he saw her in the parking garage with his wife and didn't do anything, didn't know what to do. So part of the problem is our communities don't know what to do when they're there. We have to educate them. I don't know if changing statute is going to help us. I'm actually case law. I've been committed. And part of commitment, too, is that families don't understand it. My mother was the OLCC spokesperson for 15 years, and she couldn't understand the commitment process. What we should do, also commitment process, is to get help for the families and for the people. Like in California, they have assistants who just work with the families and people and explain these things. We have in Oregon incredible innovative criminal justice solutions. We don't have innovative mental health solutions yet. Please let us be at the tables and we can make it together. Also, thinking about the costs. It's over, let's say, it's over $1,500 a day for the hospitals, probably about $2,000 now. When I came out of my commitment, I was handed a bill for $30,000. So not only did I lose my civil rights, I had to handle it. They go to the people first. And when I was helping to build Unity, a psychiatrist who handled me or took care of me in the legacy system actually apologized to me and said, "I'm sorry, I don't think I did very well by you." And so we have systems that are just not working. The clinical systems, one thing that I think we need is quality assurance with services. Why do we have hospitals that we don't want to go to? Can't we have treatment in hospitals that work? Can't we have community systems that work? We need that quality assurance and choice. And one thing that wasn't mentioned today is the 14-day diversion. So we do have that system. Are you familiar with the 14-day diversion? So the commitment, you get in there and you can be chosen, let's say in 5 days to have a hearing, or you can choose to stay in for 14 days. So that's what my doctors have done with me. By my choice, I stayed the 14 days and got out of it. So out of whatever confusion I was in. So I am not here to support 763. I'm here in opposition just because I think it can come up with better solutions. And, I would have loved to be on the committee. I just met Judge Wolke this morning. I don't know you, Senator Brzezinski, besides the Criminal Justice Summit. But I think we need voices like ours so we can come up with good solutions. And also, I made the film on civil commitment in Oregon. I don't know how you missed that. So thank you very much. I'm not in support because I don't think it's going to work. Thank you.
All right, thank you. Any questions for the panel? Senator Gelser?
Thank you, Mr. Chair. Kind of in talking about the system and a compassionate system, the concern that I have about expanding, actually there's two concerns that I have about expanding commitment. I remain very concerned about the basic civil right issue of being able to make a decision about what medication to take, where to live, what type of medical treatment to seek. And it's hard for me to get to a place that I'm comfortable taking that away from another person just on the basis that their behavior or their thoughts or their beliefs make me uncomfortable or I don't understand them. I see that that's different at the point where a crime is committed or there is a threat, and that's what happens to all of the rest of us that haven't been labeled with a mental illness. We can be strange, we can threaten things, we can be a weird neighbor, and I'm using that word weird not to be pejorative, but just the way that people might describe them, but we don't talk about taking their rights away and forcing them to take medication or have a medical treatment that they don't like. So I just philosophically really struggle with that civil rights question. But the second piece is, if we talk about a compassionate system and not intervening until there is an injury, which again is what we do with people that aren't mentally ill, why don't we back up and look at more effective, less expensive, less invasive ways of supporting people by expanding access to community-based mental health care before people are in crisis, before they have gotten to a point where accessing treatment is something so difficult for them to consider? Because every time we expand commitment, every time we expand that level of institutional care, it becomes more expensive and more difficult to provide that support on the front end, which allows people to avoid getting to that point of crisis, allows us to not be at the place where we're deciding, does the end justify the means of taking these people's civil rights away? So that's, I don't know that's a question more than a statement.
I think those were two statements.
Yeah.
So any other questions? Thank you all very much. Our next panel is going to be 4 individuals. I have Chris, I believe it's Boundifer? Boundiff? All right. Tina Gottschall, Don Baglin, and then I believe it's Mike, maybe Bauer. I can't tell. Bo, okay. Go ahead. You can come on up. I've got 4 chairs for the 4 of you because apparently y'all 4 all wanted to come up together.
Yes, we did. Thank you, Senator. Chair Prozansky, members of the committee, my name is Chris Boneff. I'm here representing the state chapter of the National Alliance on Mental Illness, here to speak in support of Senate Bill 763. Civil commitment, we're an organization that represents both family members and people living with illness. I myself actually am both. I came into NAMI as someone who lives with illness, and then am raising now a child who is in special education with a mental health disorder. This is a tricky issue for my organization in that you don't want to open up the floodgates of a commitment. We certainly don't want to deny people their liberty. At the same time, we work with a ton of families where it is clear they have a family member who needs an intervention, and yet that intervention comes so late that they are incarcerated and become aid and assist, or that intervention comes so late that they've been allowed to cycle in and out of the hospital, doing more damage to their health until such time as they reach the point where they are such in imminent danger that they qualify for commitment. We believe this is a reasonable change. We believe this is a modest change. We believe this change will target a population that we're serving now at significant cost to this state. Right now, our state hospital is overwhelmed with what we term aid and assist patients, people who are unable to aid in the legal proceedings against them, and so we send them to treatment, very expensive treatment, and yet it has nothing to do with health care. There's no long-term healthcare goal. There's no connection to the healthcare system, as the Oregonian is detailed. Basically, we process people, finish the legal proceedings, and let them go back out into the community without a connection to healthcare. All of this is done with healthcare spending. What we would rather see is someone entering through the civil system versus the criminal justice system, being alleviated of the accused crime and having a criminal record, and actually getting on the civil side using healthcare dollars appropriately, where we can then coordinate with community care and hopefully hand off and transition effectively. We have some families who can better express the frustrations that we encounter around the state. We're not sophisticated enough as an association to know, is this a case law problem? Is this a misinterpretation of case law? Every county does it differently. Sometimes you can get a civil commitment investigator to actually investigate. A lot of times you can't. They're not willing. We lack uniformity, we lack predictability, and we hope this language brings that to our state. We do support this with some trepidation and with a lot of humility. You can't point to a period in Oregon's history and say we did civil commitment well. In fact, it was 13 years ago that the U.S. Department of Justice came in here and said, you are fundamentally violating people's civil rights by putting them in the Oregon State Hospital. 13 years later, the Department of Justice is still here. We have not improved enough to get rid of the federal government who is worried about the civil rights. It is contingent, if we pass this legislation, it is contingent upon all of us to make sure that this is implemented effectively, people are treated humanely, and recovery becomes the focus and our purpose rather than just another place to park somebody. To the issue of community supports, this can't be done in isolation. This must be done concurrently with the investments that are being proposed in this session. Oregon is one of the few states. We were one of the first states that expanded Medicaid, so we covered a whole bunch of people who didn't have coverage, including a lot of adults living with serious mental illness. This state, this legislative body has put a lot of investment where other states have cut mental health funding. Right? And in this session, there are other pieces of legislation that your colleagues in healthcare and in education are considering that we believe work hand in hand with this legislation. Senate Bill 1, Senate Bill 22, right? Senate Bill 137 with amendments, Senate Bill 138. The governor's request for housing will be coming back for more housing to create more crisis respite, more transitional housing, more treatment housing. There's a proposal in front of the legislature to create some peer respite. All these have to work in concert together for this system to lurch forward in a positive manner. So, thank you.
Thank you. Who'd like to go next?
Go ahead.
Would you like me? Thank you, panel, for allowing us to be here and speak today of our personal experience. My name is Tina Gottschall, and I have 3 children, 2 of which were diagnosed with a genetic heart defect. Upon their diagnosis, we were immediately advised to put them on medication, and we did. They were not symptomatic, but they were put on their medication. Our 3rd daughter was diagnosed with bipolar schizoaffective. She had to try to commit suicide to get her help. We entered into this new family challenge not knowing how bad it had to get before we were able to get a civil commitment. In fact, it was something I wanted to try to avoid. It sounded scary, and it sounded almost like a betrayal. And by the time we got to that point, I was hoping and wishing and praying for a civil commitment. It was the hardest thing that I had done as a parent, to sit and testify that I needed my daughter to be in a safe place where she was mandatory that she take medication. I also heard her physician say because of the overdose she took, she should not even be with us. So it felt like I needed to push forward because she was allowed to survive this, and I have friends who have had children who did not. After her civil commitment and she was put on the proper medications, 2 years we had a respite. She worked in the family business that we all run together as a family. She decorated her home for the holidays. She raised her children. She spent time and quality time with her husband. After that 2 years, she decided she didn't need her medication. We saw the sign very, very early, just in her conversation. Because of the family safety plan we put in place, we knew when she was getting ready to take a turn. So we tried to do this as a family, and it was too much. It was too much for us because she started to crash very quickly. She went to the emergency room, and she had told us on the way there, I want to go to a place. I need to go to a facility. At that point, she knew she was in trouble. After a 3-week stay of little intervention in the hospital, she became catatonic, would not wear clothing, When I saw her, she was covered from head to toe with bruises. Both of her veins in both arms were blown. To me, that's more against her civil rights than a civil commitment. We were then allowed to have a hearing, and we got her civilly committed. Within a short period of time with the proper medications, she responded well. She started to come out of it, and she is back home with her family. This morning, the conversation I had with her, she said, "Mom, I want to do life. It's just, it's like a bowling alley. I need bumper pads." And I believe that this bill could be a bumper pad. Thank you.
Thank you. Who'd like to go next? Okay.
Which slide? Yeah.
That's good.
I'll speak loudly. Good morning. My name is Donald Baglin. I live in Roseburg, Oregon. In early October 2018, our son, Brett, age 19, experienced a psychotic break. I had never even heard of that term before this happened. Essentially, Brett was becoming more and more reclusive, speaking less often, and partaking in unusual activities. Some examples of these unusual activities were turning on every sink and shower in our house, taking furniture and pictures outside, throwing away food, constantly pacing around in a circle, and howling. We could not get Brett to get in the car with us, let alone go see his therapist at Compass Mental Health. 2 days later, Brett called the police when we refused to give him all of his college money so that he could move into a motel. The police asked that we take him to an appointment with his therapist, and then they left. 2 days later, the police came back to our house. It was clear that Brett was deteriorating. The police asked members of the Compass crisis team to come to our house. They determined he was not a threat to himself, others, and he could take care of himself. They left and suggested we call 911 if there were any more problems. The next day, I had to have Brett arrested for menacing harassment when he came at me with a old school style compass with a steel point and a stapler, demanding his college money, and pushed me into a file cabinet where he knew the checkbook was. We sought assistance from Compass in figuring out what was going on with him. We were told they could not speak to us about Brett's condition because he had not signed a release of information. Compass suggested we file a notice of mental illness. Finally, we located the form, completed it, had our signatures notarized, and then had it filed in Douglas County. Compass Mental Health then interviewed us. We were told right from the very beginning that they would not find Brett to be mentally ill. Brett was released from jail for time served. Approximately 2 weeks later, we found ourselves in a similar situation. This time, Brett dressed up in all black and walked around town with a flamethrower. A little background here. This flamethrower is produced by the Boring Company and Elon Musk, and is technically, under California law, the product is described as not a flamethrower because it does not shoot flames more than 10 feet. Essentially what it is it's an asphalt burner with a propane cartridge on it, but it looks like it's a flamethrower out of some kind of movie. Fortunately, Brett did not have the propane cartridge necessary to make the unit work. We advised 911 that he was walking around town with this not a flamethrower, but he did not have the propane canister to make it work, and begged them to let the officers know that it wasn't an active weapon. Later in the evening, the police came to our house and said they were tracking Brett very closely, but he had done nothing wrong. Finally, around 1:30 in the morning, the police asked us to come and pick Brett up at a nearby hotel. By noon the next day, Brett was once again in jail for harassment. This time after he came at me with a barbecue iron, screaming, "Join the militia or die." Once again, we filed a notice of mental illness. Once again, Compass completed an investigation and found that he did not meet the test of mental illness. Once again, they told us they could not talk to us about Brett since he had not signed a release of information. By Thanksgiving week, and after living in a motel for 10 days after being released from jail, living in a motel provided by Compass Mental Health, Brett agreed to go to an adult foster care facility. We're not sure exactly what happened there that night at the adult foster care facility. The next day, he was in Mercy Medical Center. All of this information was coming to us in little bits and pieces. The next morning, Wednesday, before Thanksgiving, Brett was on his way to an acute care center for treatment. Over the Thanksgiving weekend, we learned he was on a 2-physician 5-day hold. After the 5 days were up, he was sent home. We were told that Compass could have filed an additional hold, but they did not. We don't know why. After some serious begging and insistence, Brett signed a release of information. We were told that Brett had schizophrenia affective disorder, in addition to some childhood diagnosis of ADHD, ODD, PDD, and an anxiety disorder. Later, we learned that Brett perhaps had burned his arm with an iron or a waffle iron, or had perhaps thrown the iron in a bathtub. We just don't know. From December 12th to December 20th, 2018, Brett was once again in jail after we were unable to get him into a secure treatment facility. Once again, the charge was menacing. From there was a little progress until things became so bad that we had to call the police and the Compass crisis team again on January 12th, 2019. This time, after they both left the house, Brett slammed his hand in a chest of drawers repeatedly until he began bleeding. He then rubbed the blood all over his face with a slice of ham that he had grabbed out of the crock pot and told us he was praying to Coco, the food god. The therapist came back, called the police, and they took our son to the hospital. Everyone agreed. Everyone agreed they would find him a bed, that it was absolutely necessary. 5 days later, he was released. Once again, we were told Brett was not a threat to himself or others and capable of taking care of himself. Of course, we disagreed strongly. Upon release from the hospital, Compass placed Brett in a program called ACT. From late January until February 22, there were several events that occurred where it was clear Brett needed a secured bed. The police and crisis team were dispatched several more times. We were told by Compass that the best avenue to get Brett a secure bed and treatment would be to get him a guardian and have a civil commitment. It was explained to us that a guardian would be able to insist he go to the hospital, give up his DNA to figure out what the best medicine is for him, and otherwise ensure his best chance for treatment and services. During this time, we paid a retainer and hired an attorney to begin the process of hiring a guardian. On Saturday morning, February 23rd, Brett was once again arrested for menacing. I think it's important to note here that these last several times that the police came to our house were when we were on the phone, my son and I, on a speakerphone, working with his crisis therapist. It wasn't my son that called. It wasn't myself that called. Is that they could just tell from the phone call that somebody needed to call the police. And suddenly they show up. We didn't ask them to come. They were just there.
Don, if I can get you to summarize
I'm
conclusion.
on my last paragraph, sir.
Thank you.
Brett was once again arrested for menacing. Brett was then served with papers while in jail and now has a temporary guardian. After release from jail, he was taken to Mercy. We are now being told that he will likely be released to go home or go to the streets, which is the case. He's going to be released, I understand, today. So by my count, that's 5 times in 5 months that we've tried to get him help. And this has been our experience.
Thank you. Mike?
Good morning. My name is Michael Bowen. I'm a husband, a father of 3 children. I'm a process development engineer for a small high-tech company in Aloha. I've been a NAMI member for the last 20 years. NAMI, the National Alliance on Mental Illness, is a grassroots organization determined to improve the lives of those with mental illness. I'm here to talk about my son, Jacob. He was diagnosed with schizophrenia when he was 19. We also went through the civil commitment process. And through that process, he received some medication. And at that time, I was told when he was in the hospital that his disease was progressive and that Jacob would be in a catatonic state for the rest of his life. I remember this really well because it didn't happen. Jake has always been strong, and he fought, and his medication worked. And since that time, he's 39 now, since that time, he's found a wife. He's married. They bought a house. They had a beautiful little girl. When Jake started feeling the stress of marriage and being a father and having a house, as always, people with mental illness or anybody that's under stress, that starts to take its toll. And with him, he started to become ill again. Now, I've been through this a lot, and I knew right away that we needed to seek him help, and we started the process. And we did get Jake into the hospital. And as you hear over and over, he was released after 7 days. And they would admit that, hey, we think he needs to stay in here, but, we can't do anything. The law is tying our hands. This was the beginning of a 7-month cycle of Jake being in and out of the hospital. Now, I've been a NAMI member for a long time. I know how the system works, and as the sheriff mentioned, it gets worse over time. And I refused to let my son be a criminal. And time after time, they would say, I said, they say he cannot be placed in the hospital unless he's an imminent threat to himself and others. And I would say at that point, well, then are you telling me he must physically hurt himself or physically hurt him someplace else so I can prove there's a need? And they'd say, yes, that's what we're saying. It has to be that. So at that point every day, my wife helped me, his wife too. I would drive over there and check on him because if he's going to hurt somebody, I'd just as soon it be me than somebody else. I would call the county. Every single cycle, I would try every trick in the book. I would go to the county and say, look, his behavior's changed. I believe something could happen. If you don't help me, I'm going to go to the media, whatever it took, whatever a desperate father would do to try to get him help. So just real quickly to summarize, I'd like to touch on a few things. So he was in and out of the hospital. Every time he would get to that maybe 7 or 14-day point, he would be almost better. He would start to be there. The psychosis goes in and out. It's not a one or the other. It's a 80% psychosis or a 20% psychosis. It's always there. So every time we would get close, they would let him out. And he at this time, Jordana's moved back to her house and with her mom. And so Jake was there at the house himself. And he would just start to get better, and then he would go back and he wouldn't receive any help, and we'd go down through this loop again. So to talk about this, after that, we had to go through the civil commitment process, and he went to the state hospital for 4 months. So over this whole period, this year, he was in the hospital for a total of 190 days. And I had the figure of $1,000. I heard maybe it was more, maybe a couple thousand. So that's $380,000. Now, if just from a terms of cost, besides the compassion part, if Jake had gone in the hospital for 2 or 3 months the first time, that would have left the rest of the year for all these services. I'm just addressing your point about resources. At one point, I asked one of his case managers, could you just please go do a welfare check? And he stunned me. He said, he says, Jake's not stable enough for a caseworker to go out there. It's not safe. So it's like, what do you do? And I think it's important to try to help you understand that when we're talking about people's quirky behavior, that's one thing. But when we're talking about somebody's life who's pretty much like everybody else's, they have a house, they have a home, and then all of a sudden they go into psychosis. They're doing things they wouldn't normally do. You hear, well, they're making their own decisions. Well, they're not. They're in psychosis, and they're not making their own decisions. Their mind is broken, just like your heart's broken. If you have a heart attack, you can't just say, well, it's just a heart attack. It'll go away. So I think, I think the main thing to take away here is after he went into the hospital for 4 months, finally. And another thing that's important to understand, and this is evidence-based by government studies, SAMPS, I think. When you're having a brain attack, I'll call it a brain attack because that's what it is. When you're having this brain attack, if you don't get help immediately, then it gets worse. So by going in and out of the hospital for 5 months, we had permanent damage that I don't believe would have taken place if he would have been able to complete his treatment. And I think it's important to note here that after he went in the state hospital for 4 months, and I believe it took 4 months because he was in and out of the hospital for so many times and didn't get the full treatment, that he became stable. And then at that point, he was stable and doing better, but there was no place to put him. And at that point, it is inhumane to have somebody in the hospital when they don't need to be there. So my wife and I brought him home, and he's been home for a full year now, taking his medication. He's reasonably stable, and treatment works if we just give it the chance. Mental illness is complicated, and for the most part, I believe all the parties pushed whatever was possible within their legal limits to try to help in Jake's case, but
Mike, I'm going to need you to
this is it. Without getting treatment, the window's just too short to not get treatment. People need immediate treatment. So if you don't get people in right away, it's going to do permanent damage. And that's why this law, it's just this bar needs to come down just a pinch. So that's why I'm in support.
I want to thank each and every one of you for coming forward today, giving your personal stories. I know it's not easy, but it's very meaningful for us as a committee. Thank you very much. Our next panel is going to include Teresa Jocelyn, Becky Child, and Kevin, I believe it's Fitz. Who'd like to start? Okay.
My name is Teresa Jocelyn. I live in Salem, Oregon, and I work for the Benton County Health Department. I'm on a assertive community treatment team, and I'm a case aide. And I also have a family member who has severe and persistent mental illness here in Marion County. So I'm looking at a perspective from a worker in the mental health field and also having a family member. And what I've seen working in the field is that we do the best we can. I deliver their medications. We do this 7 days a week at the health department, and I do mini skills training sessions. And when somebody goes into crisis, it can be difficult to even get a psychiatric bed Currently, Good Samaritan Regional Medical Center has reduced their psychiatric beds by half, and this does not help. Marion County has a psychiatric bed crisis, and I know this is not part of SB 763, but we really do need to redefine a danger to self and others. It doesn't work currently as it is. It's difficult. And we do a fairly good job of keeping the clients we do have stable, but it's 7 days a week. And if we could get to them before they got to the point where they need to be committed, it would, you know, according to what's going on now with how it is, I'm not very good at speaking, I'm sorry. My son was in the middle of Lancaster Drive several years ago screaming, "Kill me." Do you think he could get a bed in a psychiatric unit? No, they put him in jail for disorderly conduct. And he's a frequent flyer in our Marion County jail system. Because of disorderly conduct, he won't take his medications. He has severe and persistent schizophrenia. I can't get him in the psychiatric unit. And it's frustrating, as all of these other people's stories have shown that I've heard. We need to do something to redefine what it is, what's severe, to get someone committed, because it doesn't, you know, somebody jumping off the Center Street Bridge and oh, well, now is that the point where we can finally put them in the psychiatric unit if there's any beds? Do something. Okay. This doesn't work. And I'm sick of this, but I love my job and I want to see help for my clients.
Thank you.
Thank you.
Becky or Kevin, who'd like to go?
Good morning, Chair Przansky and fellow committee members. My name is Becky Child. I've submitted written testimony to you, but I'm going to deviate from that a bit and talk a little bit about my personal experience. I am currently a PhD candidate at Portland State, and I have been homeless 3 times in my life. I was hospitalized more than 20 times in my life. I've been threatened with civil commitment more times than I can count. I never did get civilly committed, but I can tell you as somebody who's been homeless, that this definition scares me. There are not enough checks and balances in the systems. Abuse still happens in our system. And while I empathize with the people who are here who said that civil commitment has helped save their family member's life, it also causes problems for people. And it also causes death too, because some people don't find it helpful, and some people have found it really painful. The first time that I was threatened with civil commitment was the first time I was hospitalized. I didn't even know what a psychiatric, I'd never been in the hospital a day in my life until I was in a psychiatric unit. And the psychiatrist said to me that if I didn't move back home with my parents, I was 19 at the time, that he would court commit me. I had no idea what that was. I didn't know I had rights. But I moved home with my parents, which was an abusive situation. And so for the next 6 weeks, we fought continuously, day and night. And then I made a serious suicide attempt 6 weeks later. I do believe that people can get better. And part of why I do the advocacy I do, and I do it with folks who are really difficult to serve, is because I have no doubt that with a certain twist of fate, I could end up back in this fucking mental health system again. And it still sucks. And I just want it to be better.
Thank you.
Thank you.
Kevin.
Excuse me. For the record, my name is Kevin Fitz. I'm the executive director of the Oregon Mental Health Consumer Association. It's an all-volunteer organization. I don't get paid. I'm just a grassroots advocate on behalf of people with mental health issues. I'm having some challenges. I'm an individual, like one of the previous panelists said, people sometimes have extreme states of 20%, 80%. I was up late last night till probably 1 in the morning obsessing about what I was going to tell you. And I haven't decided. And so here I am. I want to tell you a little bit of my story. At 19 years, let me take it back. The last grade I graduated from was 7th grade, Sheldon Junior High School in Corvallis, Oregon. From then on, from 7th grade, 8th grade, 9th grade, I was bullied, called a lot of slur names having to do with homosexuality and sissy and disco and I was brutalized. My father was an alcoholic, and I was brutalized at junior high and high school and didn't complete it. Came back to Corvallis at 17, 18 years old, enlisted in the United States Army, went out was in Fort Lee, Virginia, had a psychotic, it's similar to what these people were saying, 19 years old, had a schizophrenic, what is labeled a schizophrenic or psychotic break. Came back, left AWOL after multiple months of psychiatric hospitalization, United States Army, back to Good Samaritan in Corvallis, Oregon, in a psychiatric room. Then I enrolled in community mental health in Benton County, ended up in Damage State Hospital under commitment. They put me in Damage State Hospital, was there for 6 weeks, ended up back in Corvallis at a place called Janus Home, got kicked out of that for a term that I have, as a customer, as I'm an Oregon Health Plan customer currently, that I have received over 35 years of public mental health services, is that I'm difficult to treat and I'm medically non-compliant, and that I have a hard time trusting medical authority. And that has been the MO of my experience through your community mental health system. I don't want to make an argument that people in psychotic or extreme states do not need some significant amount of containment, physical containment, for their safety and for their father's safety and for people on I-205's safety. But I do think, and the Supreme Court has ruled, there is a difference between containing me, putting a physical barrier around me, and then taking the next step and putting a chemical agent or an electricity on my frontal lobes or my cerebral cortex. And that we should have caution. I'm not here to say we don't have public safety issues. We don't have a huge amount of people who, on a scale of 1 to 10 in behavior and mind problems, are at 11. There's a huge amount of them. I live out near 82nd in Southeast Portland, and every day when I take the bus, there's a lot of wounded Kevins out there with no family, with no partner, with no sister, with no connections to people in politics, zero. These people have been abandoned they got the treatment that they needed and it helped them. Somebody defined what stabilization was for them, the mentally ill. I can tell you, there is nobody in Oregon who knows as many people who have had extreme states, what psychiatrists label psychotic or schizophrenic breaks. I've been doing this for 35 years. Why don't you know about me? Because I have no political action money. I'm a volunteer, and we're trying to compete with very well-funded industries that will give you the idea that we're talking about exact science.
Kevin, I need you to...
The last thing I want to say, in 1972, the American Psychiatric Association could diagnose you of having a mental illness if you identified as a homosexual. We're not talking about exact science. One other thing, you don't put baby chicks with shallow breathing lizards. There's no co-mammalian regulation. People in emotional psychiatric distress need to be around people they can be vulnerable and they can trust. And the challenge is, when we're not invited to the table, the people who will tell us what we need best will tell us what our treatment should be. You're not listening to the voice of the customer if we're not included in the discussion. I'm not against this, Kevin. I'm just saying slow it down.
Kevin, thank you very much for your testimony. Thank you all very much for coming forward and sharing your stories. I'm going to call up Bob Jundoff, Chris Anderson, and Jack Harak, maybe? Hotchick. And we're getting closer to that time of... So I'm going to try to ask the panel to take about 10 minutes. I have another panel after this.
I'll get going then, Chair Brzezinski. Chair Brzezinski, members of the committee, my name is Bob Junda from Disability Rights Oregon. Disability Rights Oregon opposes this bill primarily because in the process of it being developed, people with lived experience were not at the table, were not invited in any numbers to be at the table.
Let me just correct you there. That was a work group that I had. I know that invites went out to many people, including your organization. Please continue.
Thank you, Chair Brzezinski. I think if you look at the membership of the committee, you will see that there is a very small voice of people with lived experience. And the only recommendation I have for this committee is that it listen to the voice of people with lived experience. We have heard from professionals, we've heard from law enforcement, we've heard from a variety of people in this process. And I think it's very important to listen to that voice. Thank you.
Thank you.
Chair Brzezinski, rest of the committee. My name is Kristen Anderson. I live here in Salem. I live with bipolar 2 disorder, and my son lives with bipolar 1 disorder and is on the autism spectrum. So I speak as a person who has had challenges getting appropriate services for myself as well as a parent trying to get challenges for their child. And my heart goes out to the other parents who have spoken today. It's just, for me, a lot of what I heard were the flaws and challenges in our system that leads us to crisis. And with this expanding care, when there's crisis, is the part I have problems with. And I think we really need to look at and do a better job about providing support before it gets to the point of needing a commitment. And I have worked as a family peer support specialist, and in that capacity, traveled the state and connected with many families, young adults, and professional providers. And I worked on the Oregon Center of Excellence for Assertive Community Treatment, providing technical support and doing fidelity reviews, again, across the state, meeting many providers, workers, and people receiving ACT services. Currently, I work at the state hospital with people of all commitment types, and my experience in both using and working in both our child and adult systems is that our behavioral health systems are fundamentally flawed on a lot of levels, and particularly how it intersects with other systems such as judicial, and this is across the lifespan. And my ask is to address some of the concerns Senator Thatcher and Senator Gelser you've mentioned already today. There is another bill before this committee. You're not hearing it today. It hasn't had a hearing yet, but it's Senate Bill 374. I really would ask, before moving ahead in one small area that could have unintended negative impacts in other parts of our system, really trying to move away from a siloed approach and have that Senate Bill 374 is asking for a task force just to focus on the aid and assist. I really believe we need to look at the whole system across the lifespan, children, seniors, how it intersects with judicial, with housing. And so I would urge the state to not pass this legislation now as a kind of Band-Aid fix that will probably cost more money, but really take the time to look at our whole system comprehensively before making any serious changes to our system. Thank you.
Thank you. Jack?
I'm Dr. Jack Hotchuk. I'm a retired psychologist and program administrator, over 45 years of experience in mental health systems. I've worked at Oregon State Hospital. I was mental health director at Lynn County Mental Health in this state. Worked in 4 other states as program administrator of different organizations. I've been involved in directing, managing, and implementing mental health program crisis services and civil commitment procedures, as well as inpatient departments. I have some prepared things here, but I want to interject because some of the information that was provided to you represented, even though it was said often, that these things often occur, the things they were describing occur, if you look at actual data, rarely. Doesn't mean that they're serious at the time they occurred and warrant serious attention. But how we get I was involved in, I was actually the director of large portion of the very services I just described in one of the 4 mental health centers for public mental health care in Denver back in the mid-'80s. And that was when ACT, Assertive Community Treatment, was first introduced. And our management team decided not to move ahead with ACT because of its reliance on outpatient civil commitment. And we know that those of us with that kind of training know that when you start, the more you start to civilly commit individuals, the more you get individuals not even approaching the services available. And that becomes a serious problem because once they stop coming to the services, stop trusting that they can really tell you what they're thinking without you getting scared and taking away their rights, the crisis then develop. And that's what we have. And what I think you heard plenty of here was excellent documentation about the need for services which will preclude the development of crises. Just has been stated, I can provide you ample evidence from many trials over years now. And as Senator Gelser pointed out, the more that we can get those services, we don't even need to broaden it ever at all the civil commitment language and criteria. We need to use it when necessary. Mr. Bonoff, I thought his words were well chosen when he said that he supported this with trepidation. And trepidation is the right word because this has the potential to backfire. The history, the research history on assertive community treatment is that it was failing and failed in the form when it required outpatient commitment. I'm on the advisory board of what's called OCEAC, the Oregon Center of Excellence for Assertive Community Treatment in the state. I've been on that advisory board since the inception of that organization. This organization does everything in their power to avoid any kind of outpatient commitment, and they put great emphasis on the front end of services delivering, also accessing housing, employment, and so consequently, they're very successful. This organization is one, I love to brag them up, actually, because they're so effective. And again, they're able to avoid, and sometimes they even help certain organizations and entities in the community understand why if you're going to try to add outpatient commitment, that may complicate things here. And they have adequate evidence to show that. So let me tie up.
I need you to wrap up. I got one more panel, and we're almost
I
done.
understand, and I know that a lot of other people talked at length here. So let me just, I won't use nearly that much time. Anyhow, let me just finish up with that, and that'll be good. Thank you very much.
All righty. Thank you very much. I appreciate y'all coming forward. We have one last panel I'd like to get their testimony today. That would include Rebecca Edens, Jerasa Jerome, and Sherry Capobianco. Okay. Who'd like to go ahead and get started?
I will.
Okay, thank you.
Hi, good morning. My name is Sherry Capobianco. I'm an author, advocate. I deal with a lot of abuse victims, a lot of kidnappings, hostage situations, usually from organized crime from East Coast to West Coast, but today I'm here as a mother. 5.5 years ago, my daughter was an outgoing, beautiful teenager, wanted to be a cheerleader, was boy crazy. She was absolutely amazing. One day, she just wasn't herself anymore. She started reading the Bible profusely, thinking it was the end of the world, and she quit eating, she quit drinking. I didn't know what to do. I didn't know what schizophrenia was. I didn't know what psychosis was. I didn't know any of that. So I called for help, and they sent over some police officers, and the police officer said that she was not in danger to herself or others. I continued to do this for 2 weeks. She was dying in front of everybody's eyes. When I finally did get her help and I got her to the hospital, which was extremely hard, she was in ICU for 3 months, the Children's Hospital for 7, and then the Children's Farm Home. She came home to me still unwell. Still trying to get her more help as she continues this behavior. I've been told way too many times that it's not illegal to be crazy, and that she's in psychosis, but she's not a danger to herself or others, which is not true. It doesn't even make sense. To this day, 5.5 years later, my daughter is still not better. I've not been able to travel and speak and help others like I used to. My other 3 daughters and 2 granddaughters have suffered with my relationship. She still isn't herself. She's anywhere between a 4-year-old and a 10-year-old, depending on what day it is. The police eventually came up with the solution to file a restraining order between her and one of her sisters. So their solution was put her in an apartment through the health department. This apartment, for 1 year, she became a prostitute. Guys would come in and out, give her drugs, give her alcohol. She didn't know what was going on. There were cockroaches up and down the walls, the ceilings. There were fire hazards everywhere. She was using her clothes as sanitary napkins. She was stuffing food down her bathtub to kill the parasites. Okay, and that was because I couldn't bring her home, but I still had to raise 3 more daughters. That, excuse my French, was complete hell.
Sherry, I need you to wrap up, please.
Okay. Bottom line is, it's been near impossible to get her help. I work with everything available in Salem, Kaiser, etc., and nurses that come to the house every day and everything, and it's still impossible to get her help. So I'm here to speak on behalf of my child. Thank you.
Thank you very much. Who'd like to go next? Rebecca?
Sure.
Okay.
Sorry. So I'm Rebecca Edens, and I'm the president of the Oregon Mental Health Consumer Psychiatric Survivor Coalition. The coalition is a group of individuals that are service users or survivors. We call ourselves psychiatric survivors, meaning that we survived psychiatric services. I know it's really difficult because I've heard the stories of the family members, and that was my story too, right? So some of us that I want you to know that there are a group of individuals who have been through the service delivery system, who are currently in the service delivery system, whose experience in the service delivery system is one that is traumatizing to them. People within that are civilly committed and forensically committed in the state of Oregon who have to deal with issues concerning forced drugging, because forced drugging is forced drugging. Seclusion and restraint is seclusion and restraint. The things that we experience when we are hospitalized, what we are experiencing when those things are being forced upon us is, it feels like torture, because sometimes it is torture. And I know that's hard to hear. There is a whole nother aspect to once you get civilly committed. There's a whole nother thing that we don't want to talk about. And one thing that Oregonians do and what they do best is they protect the human rights of all Oregonians. It's just what we do. So when I heard you say that we need to be careful to protect human rights, we do. We also have other civil rights. We have cognitive liberty. We should have a choice to not be able to be forced to take mind-damaging drugs. In order to get better, we have to look at things in a more human rights-related way. If the only way for you to say the service delivery system is that I can get better, is that if I take a drug, that if I'm a man makes me impotent. I have friends, see, I'm 60 years old now, so I'm on the other end. I'm on the other end of having the effects of the medication that I took all my life. I have friends that are dying of kidney disease that's caused by the use of their medication. That's real. So we have to look at what happens. I worked at the Oregon State Hospital as an advocate. I was a patient in a different hospital. It took me 15 years to get over the traumatization that I experienced under forced treatment, 15 years. What I was initially in distress about was nothing compared to the distress that I experienced after receiving services. And I think that that's where we need to start, all the way around. We have to start and stop with our civil rights, our cognitive rights. I was born in Oregon. I was born here. I was born here, and I was taught when I grew up here that I had certain inalienable rights to liberty, to freedom. I want you to just consider for a minute to look not look at us as mental illness. We're people.
Rebecca, I need you to summarize, please.
I will, thank you. So I'm just asking you to really read my testimony and consider that until you decide who you're going to intercept and when you're going to intercept them, is that you actually come off of the hill, go down to the hospital, and actually talk to people that have been civilly committed. Ask them about their experience. We wouldn't have been sued if there wasn't something wrong. And I work there, and I can tell you the something wrong is not fixed. Not only are patients being traumatized, but professionals that work within the system are being traumatized. Our public servants are being traumatized along with our patients because they can't provide the care that they were trained to do. So please, I'm going to wrap it up.
Okay.
I'm going to wrap it up as an Oregonian and as a human being. And I am either an Oregonian or I'm a human being or otherwise I'm a mental illness. I'm either a human being or a person that the only solution that you can find is to put me in a cage like an animal.
Rebecca, thank you very much
thank you for listening.
You bet. Thank you for your testimony.
Hello, my name is Jerusha Jerome, and I'm a registered nurse here in Oregon. But more importantly, I'm a mother of a brave young man. His name is Elijah, and he has been diagnosed with schizophrenia 2 years ago. Was his first psychotic break. I come to you as a mother, and I come to you as a nurse, being in the healthcare system. I want to inform you what anosognosia is. I never knew what it was. I can barely say it most days. But what it is, it's a lack of insight, and it's real. As a society, we recognize it in Alzheimer's. We recognize it in stroke patients. But we have failed to recognize it in some cases of mental illness. 50% of schizophrenia patients have anosognosia. They have no insight. The part of their brain that is affected by the illness does not allow them to see what is going on, even though it's evident to everybody else around them that they need help. One of my experiences with my son that I'd like to share with you is he believed early on in his illness that he was being chased by people and that they were going to kill him. In my attempts as a mother to get him help, I was trying to drive him to the Unity Hospital to get him there. He almost jumped out of my car. I was on the crisis line the whole time, trying to get him the help that he needed. And pretty much the end result was, I'm sorry, ma'am, you're in a hard situation, but there's nothing we can do for you. And I literally bawled because I'm calling the crisis line. The people that are supposed to help me get my son help, and I couldn't get him help. He tried to cut cameras out of his chin. I took him to the emergency room. I was told that's not enough. That's not enough to get him any care involuntarily. Then 4 months later, he's taking a knife out of my drawer and telling me that he's gonna cut them out because nobody will help him. I called the cops. I called the crisis line, was on hold for 8 minutes. I called the cops I couldn't get through to anybody on the crisis line. He destroyed my home and then left, so I filed a missing persons report. He came back the next day, and fortunately, I had someone who would listen to me and my story of what I saw, the suffering my son was going through, and the police officer took him to Unity Hospital, I believe against protocol. He was
I'll need you to wrap up, please.
held there for 14 days. And all I can say is I'm here because there's got to be some kind of change for everyone in our current systems. I 100% agree with people having the right, but you got to look deeper. There is medical evidence that some people don't have insight. So it's very difficult for them to make their own decisions.
Thank you very much. I want to thank each of you again as the others have come forward and told us your personal stories. I know it's difficult, but it's very important for us to hear, so thank you very much. With that, I'm going to go ahead and do a couple of things. First of all, regarding Senate Bill 763, I'm going to incorporate by reference all of the testimony that has come in online into the OLIS. We're going to leave the record open for additional written testimony till 5 p.m. this Wednesday, 2 days from today at 5 p.m. I'm also, by incorporation of reference, the testimony that came in on Senate Bill 362. And then lastly, the bill that we did not hear today, Senate Bill 762, because we ran out of time, we'll consider potentially rescheduling for a time in the future.
Thank you, Mr. Chair. Would it be possible, I was looking through the testimony and recently helped a constituent get personal information about himself out of the record because an employer was finding it. Would it be possible to go and redact the last names and maybe locations where people are living when they're talking about third parties' medical information from the OLIS testimony, since we don't have their permission, the individual's permission to have their medical information in OLIS?
All right, so first of all, you're hitting me with something I'm not sure of how the information came in. If it's part of OLIS, we'll talk to see what we can or can't do, because it's a public document, and if it's been submitted by someone, I can't make that call without having more consultation within the building. We'll
That's
take
how
those
we've done it in Human Services. It happens a lot of times in that committee, and it's just when it's a third party, we've taken it out, so we're not putting anybody in a HIPAA
We will
violation.
try to honor that, but I have not dealt with that, and so we'll have to make certain. I don't want to make promises to a lot of people on the record. When something has been publicly filed, it's been publicly filed, so we'll see what we can do. Any other comments? With that, I'm going to go ahead and close the public hearing on 763. We've already closed the public hearing at 362. We're closed for today, and I believe we're back here at 8.
8 a.m.